Good morning, everyone. Firstly, I would like to congratulate the teams for making it to the semifinals of the third national virtual moot court competition being conducted by Thomas George and Associates. My name is Shweta Surinder, legal intern of Thomas George and Associates, and I will be your court master for today. Our judge for the semifinal round is Advocate Thomas George. Advocate Thomas George is the founder and managing partner of Thomas George and Associates. His educational qualifications include BA LLB and postgraduate diploma in marketing and sales. Thomas George and Associates was founded by him in the year 1998, and the firm has ever since dealt in all kinds of litigation and as well as non-litigation works. Since the establishment of the firm, Mr. Thomas George has represented the firm in a plethora of cases. I will now proceed to explain the time division granted to each counsel in a single team. Each team is allocated 30 minutes to present their case. Each speaker will be given 15 minutes unless indicated otherwise by the team. Placards indicating time will be shown 3 minutes prior to the lapse of time allocated to a speaker and finally once the time has lapsed. 30 seconds each will be allocated for rebuttals and surrebuttals. Speakers kindly note that disclosing your name or the name of your institute shall attract a penalty in the form of deduction of marks. We have team TGA 11 representing the petitioners and team TGA 4 representing the respondents. With the permission of our learned judge, we shall commence the semi-final round of the third virtual national moot court competition.
Thank you, Ms. Surendra. Now the petitioners can start.
Petitioners Counsel, could you specify your time breakup, please?
Each of us will be taking 15 minutes each. If that is going to exclude the rebuttals and rebuttals.
Okay, you may proceed.
Thank you so much, Shweta. Good morning, everyone. The counsel seeks permission to address the bench.
Go ahead.
Much obliged, Your Lordship. May it please the Honorable Court, this is counsel number 1 appearing on behalf of the petitioner in a matter of XYZ versus the Republic of Parliamento. The counsel seeks permission to collectively address the benches, Your Lordships.
Go ahead, go ahead.
Much obliged. If Your Lordships are well versed with the facts of the case, the counsel seeks permission to summarize the issues for the same to the honorable bench.
Go ahead.
Much obliged, Your Lordship. So the counsel number 1 would be dealing with the issue of whether or not the government is justified in taxing digital currency, digital assets, non-fungible tokens, etc., which is not legalized yet by the Republic of Parliamento. And its learned co-counsel would be dealing with the issue of constitutionality.
Go ahead.
Thank you, Lordship. This issue shall be dealt with in 2 different limbs, wherein the council would first like to acknowledge the necessity of having a regulatory vetting first for any new financial technology to be adopted.
I beg your pardon? Regulatory?
Vetting, censure.
Yeah.
Your Lordship, for the ease of your disposal, the council would like to share the GURP committee report for ease. Just a second. Yes, is the compendium visible?
Yeah, I can see it. Go ahead.
Yes, Your Lordship.
You don't have to bother, take the pain over this. You can just, I'm having the thing printed with me. You can go ahead. You can close the sharing and you can tell me the paragraph. I'll go ahead.
Much obliged, Your Lordship. If the compendium is at your disposal, then certainly so.
Yeah.
Your Lordship, if the council would like to direct your attention to the GURP committee report in the compendium, which the highlighted portion, which talks about the legal and regulatory risks.
This is on page number or paragraph number?
It is on page number 9 and paragraph number 1.6.2.
.6.2.
Yes, Your Lordship.
It's not there in this?
The compendium on behalf of the petitioner. It should be there.
Yeah, yeah, I'm having it, the compendium on behalf of the petitioner. That's on which page?
Page number 9, Your Lordship.
Okay, okay. You please share the compendium because I was informed compendium is not there with me. You may
All
please
right.
share it.
All right.
Sorry.
All right. No, that's
Uh,
good.
Miss Surender, you just adjust that timing for them.
All right.
They
Is
should
it
not,
possible now?
they should not be looser on this time.
All
Yeah,
right,
go
Your
ahead.
Lordship. Your Lordship, as it is under your perusal, the highlighted portion of the GARG committee report, which was a high-level interministerial committee, here the word regulatory vetting and development of industrial standards are there.
This is which committee meeting?
The GARG committee, which was
Yeah.
tabled by
Okay.
the parliament
Yeah, yeah.
in the
Okay.
year 2017.
Hmm.
So that would be adding up to the first limb of the argument, Your Lordship, for the council. So it would first like to acknowledge the necessity of having a regulatory vetting or censure or deliberation of a sort for any new financial technology to be adopted before the exigency of tax. And the second law would deal with why there is a need to have a legislation first and taxation next, which are clearly realized throughout the variegates of risk in the regulation of virtual digital assets. So, Your Lordship, just at the outset, the Council for the Petitioners would like to respectfully submit to the bench and clarify that this pleading to quash the impugned sections 115 BBH and Section 2, subclause 47A of the Income Tax Act on the grounds of unconstitutionality, it is not to be deemed that the people are evading such income from being taxed. It is only a modest request that without any legislative competency for the same, which would act as a catalyst to regulate the mass of volatility of this quantum, it would only be ideal enough to be taxed after being governed by the legislation of a sort.
May I pause for a minute here? I would like to have a clarification.
Indeed,
Now, we had this cryptocurrency and all these issues came up after the global pandemic, right?
Indeed, Your Lordship.
Okay. Now, even though before that it is there, but it became rampantly used only during the pandemic, right?
Indeed, Your Lordship.
You know very well the pandemic also was an unprecedented one, unforeseen one, or it was not expected globally, right?
Indeed, Your Lordship.
And at that point of time, certain medical issues had to be left to the health department in toto, right?
Indeed, Your Lordship.
Similarly, when a situation has come like this, why should we go for all these things? Can we not ratify it?
Your Lordship, a legislation first is necessary, then afterwards a tax can be brought into, because there are certain practical risks and challenges posed by the volatile nature of such financial transaction, which can only be curbed by a legislation or a policy framework of a sort and not by tax regime. The council would like to get to you on that by explaining their arguments in the upcoming front.
Go ahead.
Much obliged, Your Lordship. Therefore,
I am
kindly.
let me make it very clear, I am not convinced with what you have submitted.
Your Lordship, kindly allow the council to
Yeah, go ahead.
convince you. This would be the platform for the council to convince you regarding our arguments put forth.
Yes, yes. Okay.
The written
Please take
submission.
note of that, okay?
Much obliged, Your Lordship. The written submissions would only act as a buttressing factor for whatever is being put forth by the oral argument.
Yeah. Now you can remove the screen sharing, no?
Much obliged, Your Lordship, indeed. Yes. So kindly allow the council to direct the bench's attention to the various copious contemplations, plans and actions of the government and the government's aides, which bring about the risk posed by the growing digital transactions and people's interest in them, which will go unwarranted and unsanctioned for if left unregulated first. Your Lordship, on the first leg, the Council would like to throw light on the Garg Committee report, which was shared as a part of the compendium. It was a high-level interministerial committee to propose specific actions to be taken in relation to the virtual currencies, and the mandate of the committee included an examination of the policy and legal framework for their regulation to recommend appropriate measures to address the concerns regarding the risks and challenges. Certain technical terms such as scalability, transaction speed, interoperability, and even the risks of cyber security were considered and deliberated upon by the committee, because those were the quantum of the risks and challenges posed by virtual digital assets and any indulgence made by them for the transaction purposes. But these were just minuscule fallacies that had to be looked into by the government. The elephant in the room has to be the legal and regulatory risks identified by the committee. They enlightened upon the regulatory and vetting of the industrial standards. So, Your Lordship, which basically meant that for any new technology to be adopted first at a mass scale, it has to be there has to be a legislative framework which needs to be supporting and guiding it when it comes to the procedural conventions. So, Your Lordship, the digital ledger transaction, it is still at a developmental stage, although it has been rolling about for decades all around the world. When it comes to the Republic of Parliament, it is still at the at a very advanced stage. So many of the financial sector regulators and standard setting bodies are currently actively still studying about the technology, and it is any regulatory framework is to be developed by the government in order for it to be taxed. Your Lordship, it does not just stop here, but rather a lack of clarity when it comes to the ownership and jurisdiction and customer due diligence requirements are also studied about. All of these have serious ramifications on the general interest of the public if it is left unregulated. So even the committee which was formed by the government recommended building appropriate regulations and legislation for the development of digital ledger transactions because of their major role, which would push the Republic of Parliament in ushering the digital age. So hence there are still a few practical challenges that need to be resolved, because it cannot be answered by rolling about a tax regime first, just because there is a substantial growth in the number of transactions that are being taken place. So according to a survey, around $43 million transactions are happening on a day-to-day basis. This report was in the year 2019 when the pandemic rolled out. So a legislation would only help to curb all of these and bring them under one ambit, and then bringing tax next would be ideal enough for both the government and the investors, because it would curb all the practical challenges, such as the tax provisions are actually silent about the valuation mechanism to be adopted for computing the fair value of consideration on the transfer of virtual digital assets. Your Lordship, it is also to be noted that there is no governmental or commodity backup for such transaction. So at any point of time, if the transaction, the bitcoins or cryptocurrencies could lose its value, and only a legislation could bring about such value to the commodities. Let's take, for example, decentralized currencies and fiat currencies. Even fiat currencies are not legal tender which are backed up by gold or diamond of any sorts, but it still has a value because it is backed up by government. But in this case, it is not so, because people of the Republic of Parliament are succumbing to the lucrative interest posed by this niche sector. So the council would like to direct the bench's attention to another practical problem faced by the users engaging in virtual digital assets. So according to the Income Tax Act, an individual with a yearly pay of more than rupees 2.5 lakh, or who has received any installment on which a duty was deducted at a source, like tax deducted source, to which one person would be caught for, is required to file for income tax return, disclosing all profits. Regardless, there is a confusion among many as to how income from internet and digital form of money should be disclosed to income tax return, and there is no guidance on this, which is why, based on such procedural aspects, we need a legislation. Because of the disarray, the concept of income from investment in digital currencies has yet to be defined, and there is no clearance on tax collection from such profit in this manner. So,
Suppose if there is a illegal money flowing in at a rampant stage, you mean to say that you can allow that without waiting for a legislation to come?
Your Lordship, at the council has already clarified that irrespective of the legislation has not been rolled out, so it's still a non-legalized sector. Income Tax Act would not, it would be immaterial to the government as to whether or not the income arising from such transactions are illegal or not.
Republic of Parliamento is an underdeveloping country, right?
Indeed, Your Lordship.
Where the majority are poor. What do you mean by a tax, madam?
Your Lordship,
What do you mean by tax?
a tax is a charge, a tax is a levy on that is given on income. That is, a tax is a compulsory charge or
I'm
levy
not
on any
talking
income.
about, I'm just putting what is tax.
Tax is essentially what is to be filed to the government as part of a consideration for all the income that has been gained by the public, Your Lordship.
Okay.
It
So
could
what I'm saying is, when the Republic of Parliamento is having majority population is underdeveloped, and when there is a need, and
indeed.
when a section of the group of the community is rampantly making money without any accounting or any control, is it fair to go ahead allow that kind of operation? If you remember, yeah, if you
Your Lordship,
is it
please
fair for
continue.
you to ask for such a relief?
Your Lordship, your question, in order to answer your question, all the rampant transaction that your Lordship has been talking about amounts to anti-money laundering, terrorism, and tax evasion. And all of these could be curbed by a legislation first. And this was also identified.
I'm not on that. I'm not on the money laundering or illicit money or anything like that. This is a source of inflow of money or a transaction. What is happening unaccounted?
Indeed, your Lordship.
So there is a rampant flow. You agree to that? So in such a situation, isn't it a necessity on the part of the government to have a check and balance on that?
Indeed, your Lordship.
Rather than waiting for a committee to be formed and all those things. We are having committees and commissions happening years and years together.
Indeed.
By then the governments of the day are changing.
Indeed.
In such a situation, what is your suggestion then?
Your Lordship, in order to answer your claim, a tax regime would be ideal because
Please give some time.
Your Lordship,
give another 2 minutes.
Go ahead. Much obliged, Your Lordship. Your Lordship, a tax regime would only be ideal because the volatile nature of the transaction are actually happening in a very anonymous, and the source of such transactions are not called for. No, unlike intermediary transactions that are happening on a regular, the legislated intermediary transactions that are happening on a day-to-day basis also.
That is why the source of the cryptocurrency or whatever is the currency in dispute is the source and channel is not known. That's why I was asking about.
Indeed, Your Lordship. Which is why the council would like to answer in order to satisfy your question, Your Lordship. Only when it comes to that aspect of identifying the anonymity and source of such volatile transaction, a tax regime would be ideal. But if that was the case, there are much other practical problems which should be left uncalled and unwarranted for if there is no legislation, because under attack, there is no procedural aspects. The people of the Republic of Parliament are still unaware as to how considerations are taking place and how GST Act or even
the procedure is not challenged. Only the section is challenged.
Your Lordship, but the section at the outset, the council has already clarified that the legislation is necessary before
No. What I was you have agreed to the fact that inflow has to be monitored and all those things. So considering that, since you have agreed for that, what is the challenge of the section goes?
Your Lordship, on the basis of unconstitutionality, also the Learned Co-Counsel would satisfy your claims regarding why this impugned section, which has no legislative competency as per Article 265 of the Constitution, that would be dealt by the Co-Counsel. But on the other end, the counsel for the respondent, the first counsel for the respondent, is arguing on the basis that there have been contemplations on the end of the government which would make the public in the general interest believe that there could be a plausible legislation that needs to come about first.
I appreciate your presentation, and it is well taken. All the best.
Much obliged, Your Lordship. Arguendo, when such a platform which breeds in volatility and anonymity lets the users to obscure identities even further, it would
the time is up.
The counsel's extension of just 2 minutes, Your Lordship.
I have given.
Whatever is granted, just to wrap up the arguments.
Right.
Much obliged.
Go ahead.
In the case of Internet Mobile Association versus RBI, there the infamous impugned circular of RBI was quashed on the basis where the outright ban without any statutory power was laid forth by the RBI. Such a platform which breeds in volatility and anonymity, this was what was observed and
yeah, I've gone through that.
Indeed. So it was observed that if there is a breeding ground for prohibited activities, which your Lordship has also pointed out, nurtured by such volatility.
I'm not saying it's a prohibited activity. I'm not saying it's a prohibited activity or anything like that. I'm only on the ground that there should be a check and balance, right? That's all. Well appreciated.
At least even when such prohibited activities or illegal activities have come forth, which have already come forth, for the sake of having a legal basis for prosecution, at least a framework must be brought forth. Even the need for a legislation was felt by the Supreme Court previously in the Internet Mobile Association case. So,
we have already completed your time. You have placed your presentation where your presentation is well appreciated, and keep it up.
Much obliged, Your Lordship.
So, I appreciate your presentation.
So even when a bill is also tabled at a parliament, at Lok Sabha, which is awaiting consideration, it is only a request from the people of the Republic of Parliamento to bring about a legislation sooner or later. So
I got it.
Therefore, Your Lordship is humbly contended that the petitioners, though the income earned from virtual digital assets do fall into the bracket of taxation irrespective of its non-legality, it is only wise to bring about a legislation to regulate its transaction and tax it owing to its deepening perplexities. It was an honor arguing in front of Your Lordship. The Council seeks permission to recuse. Over on to the Learned Co-Counsel. Much obliged. Am I both audible and visible, Your Lordship?
Yeah. Go ahead.
May it please the Honorable Court, this is Counsel 2 on behalf of the petitioners in the present case XYZ versus Republic of Parliamento. Counsel 2 appears on behalf of the petitioner. Counsel seeks permission to address this bench collectively as Your Lordship.
Go ahead.
Indeed, Your Lordship. Counsel 2 will be dealing with the second issue, that is whether or not Section 115 BBH of income tax is violative of the Constitution. It is humbly submitted before the Honorable Supreme Court that the Section 115 BBH of Income Tax Act is violative of the Constitution because, firstly, the government has no legislative competency to levy the tax upon the VDA, and secondly, impact of the Supreme Court setting aside the ban of virtual digital assets. The first leg of the issue is regarding the lack of legislative competency to levy tax upon the VDA. The Republic of Parliamento did not enact any law to legalize the framework of digital assets, digital currency, and NFTs. So there is a need to draw a distinction between the lack of legislative competency of a state to make and enact a law on a particular topic covered by any of the list in the 7th schedule, and its incompetence to make a law abolishing or abridging the fundamental rights or in violation of any other provisions of the Constitution, Your Lordship. So when there is a lack of legislative competency, the law that is made should be void. So if by reason of Article 265, every tax has to be imposed by law, it would appear to be followed that it could only be imposed by a law which is valid by conformity to the criteria laid down with the relevant articles in the Constitution. These are the laws.
Excuse me. You might have heard me. I put a question to your colleague, and your colleague had said that you will be answering to that. The thing is, when there is an unprecedented inflow or a transaction of this kind happening, when there is no time for the government to go ahead for this, they not uh, come forward with this act and then ratify it?
Your Lordship, the council condemns that it is not telling that it should not be taxed. It is telling that without stating what is the legal position of that, it is not supposed to be taxed, Your Lordship. So that is what council is trying to contend.
Go ahead.
Indeed, Your Lordship. So these are that the law should be within the legislative competence of the legislature, being covered by the legislative entities in the Schedule 7 of the Constitution, and the law should not be prohibited by any particular provision of the Constitution. So in the present case, the legislature have no authority to impose the tax upon the VDA because the Republic of Parliamento did not enact any law regarding the legal position of the VDA. And in the case of Pesikaka case, it was observed that a declaration of unconstitutionality brought about by lack of legislative power stands on the different footing from a declaration of unconstitutionality brought by the abridgment of fundamental rights. So both this declaration of unconstitutionality go to the root of the power itself. The main root of the power here is that the want of the legislative power. The stand upon which the legislature is taking regarding that particular legal status, Your Lordship. And in the case of the National Provincial Bank versus Ainsworth, the court further noted that the cryptocurrencies are not legal tender in the sense of being a regulated currency issued by the government, but do have the fundamental characteristics of intangible property as it being an identifiable thing of a value. So due to this improper legal position of the country, it led the law being an arbitrary in the nature, Your Lordship. And it was also well settled that a law which is beyond the power of the enacting body is not a law at all. Such a law cannot acquire the validity by the mere passage of the time. And it was same held in the case of Canadian Federation of Agriculture versus Attorney General for Quebec, Your Lordship. And the power of a statutory authority to do something has to be tested normally with reference to the person or entities whom the power is exercised. The question to be addressed in such cases, it is whether the authority... Indeed, Your Lordship.
Why should I consider what has happened in Quebec?
As the Republic of Parliamento.
This is a unique situation, right? Why should I consider the judgment of Quebec?
Your Lordship, as Republic of Parliamento is an active member in the International Nation Organization, so it will have the persuasive value of the things, Your Lordship.
Good.
Indeed, Your Lordship. Indeed, Your Lordship. So the power of the statutory authority to do something has to be tested normally with reference to the person, entities, whom the power is exercised. The question to be addressed in such cases is whether the authority has the power to do the act or issue such a directive to the person to whom it is addressed. When the validity of an enactment is called into question, the first thing for the court to do is to examine whether the act is a law with respect to the topic assigned to the particular legislature which enacted it. The scope of Income Tax Act is restricted to provide for the taxability of any transaction, and even illegal transactions are being taxed, although taxing VDA does not have make them legal.
Can you please read that 115, the tax section which is being challenged?
Indeed, Your Lordship. So section 115 BBH of Income Tax Act, clause 1 states that...
You have your IT Act with you?
Indeed, Your Lordship.
You having the book with you?
Not in the book, but in e-format we have.
E-format you have? Please read it from the e-format.
Indeed, Your Lordship. So, clause 1 states that where the total income of an assessee includes any income from the transfer of any virtual digital asset, notwithstanding anything contained in any other provision of this Act, the income tax payable should be aggregate of A, the amount of income tax calculated on the income from transfer of such virtual digital asset as asset at the rate of 30%, N. B, in the clause B, the amount of income tax with which the assessee would have been chargeable had the total income of the assessee been reduced by the income referred to the clause A.
Clause 2 states that notwithstanding anything contained in any other provision of the Act, under the subclause A states that no deduction in respect of any expenditure other than cost of acquisition, if any, or allowance or set off of any loss shall be allowed to the assessee under any provisions of this Act in computing the income referred to in clause A of subsection 1, and B, no set off loss from the
Yes,
transfer.
yes. Now, I would like to know, are you trying to say, yes, this is bad in law, let us not have this. So it has to be treated under TDS?
Your lordship, the council is contending that it is not contending that the income should not be taxed. It cannot be taxed without any legal position or legal status of what
In such
happens
situation,
in the future.
now there is a situation that there is a urgent need to do something in this manner, in this issue. So what do you suggest?
Actually, in the government is trying. They already have. We
I'm
already
not
have.
asking the government. I'm not asking the government. I'm asking you, petitioner counsel. What do you suggest?
The
In such a
council.
situation, if you are in the power, what will you do?
The council will wait for the committees to give their
There's no
report,
time for it.
analyze it.
There's no time for it.
Without even though there is, I mean, even though there is very big urgency, we can't tax it upon without any proper legal status, your lordship, because it will jeopardize the position of the investors as well as the government to tax it to not know the status in a proper way, your lordship.
Are you saying who are the investors?
The people, your lordship, the people who transfer the VDA.
People mean, see, cryptocurrency, all these things which are in there, they are all the elite crowd. It is no way affecting the common man.
Indeed, your lordship, but still all people are to be treated in an equal way is what Constitution states, your lordship.
That's why if this 30% tax is collected, it is equally divided.
The 30% is a proportion which is applied upon the income of the people, your lordship.
So,
Income from that transfer.
You are saying that a law has to be equally applied, right? So this is going to be equally distributed.
Your lordship, that is equally distributed if we take it in a consideration. But here there are many other things which were left out from this section, your lordship.
What are the other things left
like
out?
stock and gold and the other things which has less tax rate when compared to this.
See, that is a different issue, totally a different issue. So what I'm only wanting to know is when there is a sudden windfall of wrong currency coming in, or which has not been monitored, when the government comes to when it comes to the notice of the government, definitely government has to take some steps in it.
Indeed, your lordship, but the steps should be taken to. I mean, the council would contend that the steps should be taken in the first place to talk about the legal status when comparing coming to the direct step of taxing it, your lordship.
The policy of the government. Policy can the courts challenge? Can the courts interfere into the policy making of the government? We the people.
If it is affecting the constitution, then it can, your lordship.
Which way? That's what I'm asking. A policy. Can you give me some? Throw me some light into that. That a court can interfere into the policy making of the government.
Council will get back to the case laws which come back to that, your lordship.
Okay, fair enough. Good.
Oh.
Go ahead. Go ahead.
Indeed, your lordship. It is further submitted that the tax rate is irrespective of the nature of income. Income can be here business, capital gain, or other sources. So government is not clear on what nature of income it wants to tax. In such a scenario, it is creating a wide scope for the government to tax the profits of any kind of transfer of such assets, as there is no intelligible differentiation and a lack of clarity over such taxation. This would hugely impact all kinds of players unreasonably. Therefore, such a policy should be struck down. It is further submitted that the tax will not be deducted on expenses nor set off against losses. The losses cannot be carried forward for the next financial year as well. All the stringent measures will not only discourage players to leave the market, but also force certain players to invest in VDA underground to evade the tax. So it is respectfully submitted that this taxation policy is highly discouraging citizens to invest in such booming investment technology, as this taxation policy is not guaranteeing the legality of the trade of VDA's profits.
I'm not convinced about that aspect of booming investment technology.
Your Lordship, the council stated it to be the booming investment technology, because if, for suppose, if it has made a legal thing, it would have been a wide scope and sector for the people to invest and gain more profits, and as well as there is a loss also, Your Lordship.
When see, government has come out with this 30% for the simple reason that the investment is with the elite. And it is not it is not applicable to the entire country. I mean the entire population. For example, you said about gold tax or wealth tax. Wealth tax is applied to the wealthy. Gold tax is for people who are investing in gold. Whereas similarly, this is also coming into that bracket.
Indeed, Your Lordship, here the council is stating that, but it is affecting at the same time the people who are even transferring it, or who even have the thought of entering into the transfer of VDS, Your Lordship.
The person who is entering into it will be knowing about it.
To know about it, here the government did put the stand of whether it being legal or illegal.
I am charging 30% because I want to control. You say it is without the ambit of law. It is a policy of the government. A policy cannot be questioned. And this is not an illegal law. This is not going to result in any criminal offense.
Indeed, Your Lordship, it is not resulting to the criminal offense, but it is putting the people in the dilemma or in the position to.
Government want to control this kind of transactions because government see that there is going to be a danger in it.
Indeed, Your Lordship, council is not contending that it should not be taxed at all. It is contending that it should be backed up or mainly sourced with the legal position to be later on taxed, and for the government and for the people to be stand at the same side of the issue or the same side of any problem, Your Lordship. That is what council is trying to contend here, Your Lordship.
Very good. I appreciate your presentation.
Thank you, Your Lordship. And in the case of the council is coming back with the issue where the court can involve with the policy, where the council told it will come back.
Yeah. Tell me.
Indeed, Your Lordship. The state of MP versus Nandlal Jaiswal in this case, and in the Kegar versus Union of India, in this case, the court told that laws that relate to the economic activities should be viewed with greater latitude, and legislature and courts should be allowed to play some joints at the same time to determine whether it is done in a proper way or not, Your Lordship.
Economic activity.
Indeed, Your Lordship.
Economic activity.
I mean, here the income is being gained and it is putting tax in that way, we have said, Your Lordship. Indeed, Your Lordship.
Well presented. Wish you all the best.
Thank you, Your Lordship. If the council is if the Lordships are satisfied with the issues, whatever presented by the council, we would like to move on with the prayer.
Go ahead.
Prayer. Therefore, in the light of the facts stated, arguments advanced, and authorities cited, it is most humbly prayed and implored before the Honorable Supreme Court of Parliament that it may be graciously pleased to adjust and declare that the government is not justified in taxing digital currencies, digital assets, NFTs, etc., which are not yet legalized. And secondly, Section 115 BBH is violator of the Constitution. Also, pass any order of the Honorable Court may deem fit in the favor of the petitioner to meet the ends of equity, justice, and good conscience. For this act of kindness, the petitioner shall duty bound forever. Prayer.
By what should the court do?
The court is asking to declare.
Hey, what are you asking?
The council is asking to declare the court.
What is your prayer?
The prayer is that Section 115 BBH is violator of the Constitution, and the government is not justified in taxing digital currencies, digital assets, NFTs, which are not yet legalized, Your Lordship.
Hence,
hence, it want court to declare that Section 115 BBH to be unconstitutional.
by?
Your Lordship? By the court.
Oh, you are asking me to declare. That's enough.
Yes, Your Lordship.
Is it? Okay. Fair enough.
The council would like to reply.
Respondent counsel, can you hear me? Could you please specify your time breakup and then proceed? I believe you're on mute.
Yes, I will be taking 10 minutes and my co-counsel will be taking 15 minutes, and we reserve 5 minutes for the rebuttal.
Okay. 1 second. Just give me 2 minutes. Just give me 2 minutes. Just give me a few minutes, sir, because yeah, go ahead. I'm sorry.
Pleasant morning to your lordship. My co-counsel take eminent pleasure and honor.
You're not audible. Your voice is breaking. Try again.
Yes, your lordship. Am I audible right now?
Clear. No, you're clear. Yeah.
Okay. A very pleasant morning to your lordship. I, along with my co-counsel, take eminent pleasure and honor while presenting the case before the Honorable Court of Republic of Parliamento, and we will be representing the respondent, the Republic of Parliamento. I will be arguing on the first set of the issue, and I will be taking 10 minutes, and my co-counsel will be arguing on the second set of the issue, and he will be taking 15 minutes, and we reserve 5 minutes for the sir rebuttals. If your lordship is familiar with the factual matrix of the case, the counsel would like to proceed forward and move forward to the first set of arguments.
Go ahead.
Much obliged, your lordship. Your lordship, it is humbly submitted before the Honorable Supreme Court of Republic of Parlamento that in recent years, the use of virtual digital assets has gained a surmountable increment. And on the flip side, it serves to be a safe haven for the illegitimate activities, such as fraud, tax evasion, money laundering, financial and terrorist activities, and bribes, which challenges the law enforcement on a higher level. The root cause of this is that the mechanism of virtual digital assets provides many ways for tax evasion. Your lordship, it is held that in the previous tax regime, there was no uniformity in the virtual digital assets. And the transactions that were made through the medium of the virtual
Counsel,
yes,
let me pause for a minute. This, you are telling this amount is being channelized for terrorism, etc. But that is not there in the anywhere in your moot propositions or anywhere. From where are you inventing this terrorism and money laundering?
Lordship, I would like to present the argument on the basis of the page 9 of the memorial, where in the arguments advanced issue 1, para 1, the counsel has represented the fact that the virtual digital assets have gained surmountable increment and they are serving as a safe haven for illegitimate activities like terrorist financing, bribes, money laundering, tax evasion.
Issue. What are the issues? Issues are they are challenging, the petitioners are challenging the 1115 of the IT Act, taxation. They are not on the footing of terror funding or anything like that. So do you have anything to say that it is for terror funding?
Lordship, the council is trying to explain with the argument that how the virtual digital assets were being an asset which was being used for other activities and not only as an activity for the digital economy and financial development. And that was one of the primary reasons why the government has decided to tax it, so that a regulatory framework can be formed and there would be a footnote for the regulatory framework, which is the government is still working on. So that was one of the reasons. But along with this, the previous tax regime, with the point that I was talking about earlier also, that does not have uniformity. And the virtual digital assets and the transactions that were occurring in that time period were not also reported. So for instance, in a circumstance where two transactions are occurring and the swap is occurring in virtual digital assets only. So there can be different platforms, but in virtual mode, the transaction is occurring. In that situation, the transactions were not reported at all and they were not registered. And due to this, they were not taxed. So in the aforementioned circumstance, there was a non-taxability which was occurring on income of transactions in pertinence to the virtual digital assets. And due to this, the increment led to a loss to the revenue of the public exchequer. And due to these events and these reasons, the government had decided to put up a tax regime which taxes virtual digital assets. If your lordship allows, I would like to move forward with the next set of arguments.
Go ahead.
Much obliged, your lordship. In order to counter this dilemma of non-taxability and a regime which was not occurring, because in the previous tax regime, there was no uniformity. To counter all these dilemmas, the government decided that they would put up a tax regime. Your lordship,
Madam, one small doubt. See, the petitioner's contention is that it is not being through properly brought in. This section which is in challenge is not due by the process of law. In the sense, the procedures have not been followed. Government has, you have straight away implemented a 30% tax you added this section and in the IT law and implemented a 30% tax on the public. That is being challenged.
Indeed, Your Lordship. Your Lordship, when the petitioner puts up the question that how the tax has been put up in the tax regime and what is the constitutionality, the question here is that the answer that would the petitioner is gaining and the respondent would like to proceed forward with is that by the Article
No.
265, which deals with the yes,
I
Your
am
Lordship.
asking the constitutional validity. Are you explaining or your colleague is explaining?
My co-counsel would be explaining that also,
Right.
but
Go ahead.
I would like to close to the question that was asked by your lordship. The Article 265 gives the authority of law to the government and the sovereign tax, the right to have the sovereign taxability. So on that basis, the government has gone through the proper chain, and it has not done something which is arbitrary in that nature. And along with that, I would like to point out that we are still working on the regulations. So the government is still asking for suggestions.
Well, yes, this
Yes,
is
Your
a very valid thing what you're saying. When you're working on it, why don't you complete it and then implement it? You yourself is
Lordship.
telling, you yourself is telling that you're working on it. Then isn't it that you have to come out through the due process? When you're working, instead if you say that you're worked out, it's different. When you say that you're working on it, let the working be completed, no?
If we will wait for that time period and if we will wait for the regulatory framework, and as we know, virtual digital assets are one of our very inflammatory topics, and all around the international sphere also, people are trying to understand the regulation that should be implemented. In all that time, if we will not implement the taxation, a lot of tax slab and a lot of tax evasion will take place. And along with that, as I
petitioners are not on implementing the tax. They are not against that. What they say is petitioner's grievance is it is not due to the due process of law.
Lordship, the respondent does not agree with that particular set of arguments because it has been implemented through a due process of law, and the government also has.
1 minute. You yourself has told that you're working on it. And you yourself is now just made a statement that even the globally also this is being worked upon. So
Lordship, we are working.
When it is being under working system, why shouldn't it be paused till working system is in place and implemented?
Your Lordship, when I pointed out earlier that we are working on by that particular argument, the council meant that we are working on the regulatory framework. And about the tax liability and tax slabs, we have still implemented that, and that particular step of providing the tax regime in a new format has been implemented in a very constitutional manner. And through that, the Article 265 also gives the government the right to do so, because it is the sovereign right of the government to put that. But along with this, my co-counsel will also be dealing with the constitutional validity and how the government is right on its footsteps when it is working on the constitutional validity. And about the regulatory framework, we are contemplating on it and still working on it, but there are two different issues. And if the lordship is satisfied with my arguments, I would like to proceed forward with the next line of argument.
Go ahead.
Much obliged, Your Lordship. Your Lordship, this non-taxability was a huge dilemma.
Give Ms. Surender, give her 4 minutes time because I have put some questions. Give her that extra leeway.
Your Lordship.
I think I have given
Your
them
Lordship.
Petitioners also got that, no?
Your Lordship.
Go ahead.
4 minutes time, sir.
2 minutes.
Your Lordship, I would like to draw your attention to page 9, issue 1, para 4 of the written arguments of the respondent. If your Lordship is with me.
Yeah. Go ahead, read it. Read it for me.
Sure, Your Lordship. Your Lordship, in the pertinent issue of taxing incomes in relation to virtual digital assets, in the case of CIT versus K. Thangmani, it was held that if the income is earned in any manner, it will be taxable. And it was noted that there is nothing like an illegal income, so far as the tax collection is concerned. Along with this, Your Lordship, I would like to point out that in the case of Commissioner of Income Tax versus Piara Singh, it was held that if any business is illegal and a profit and loss is earned, if it is not enforceable by law. But this does not explains that the profit out of this is out of taxing statute, which means that despite the fact of legality or illegality, virtual digital assets can be taxed and the government is justified in taxing them so. In the case of Commissioner versus...
Again, anyway, other than this, any more submission is there?
Your Lordship,
any more submission is there? Are you at the last leg?
Your Lordship, there is one more case, and it is about to, yeah. Just in one more case of Commissioner versus SC Kothari, it was held that if there is any business, legal or illegal, the income tax law says that the profit of the business shall be chargeable to the tax, and thus both the incomes are taxable alike. So with this, I would like to prove the argument that...
I agree, yes, I got your point. My contention is, petitioner's contention is that 30% tax is not the tax to be levied. They are willing to pay the income tax, but they cannot be taxed 30%. That is the issue here.
Lordship, in pertinence to that question and that issue, I would like to submit from the side of the respondent that the government is still working on it, and it was a new regime that we have introduced and a new system. Yeah. So we are still functioning on it. And I would like to point out that the counsel for the petitioner has depicted in their written arguments that, they have given a law of first countries like Canada to upheld in their arguments. But I would like to point out that in the case, the Apex Court held in the case of Internet and Mobile Association versus RBI, that comparative perspective provided in regards to international sphere cannot be made. And the substance ground for testing validity of action is not there, because there can be no comparison with the approach adopted by first world countries like Canada as given by the petitioner, as they have developed economies and economical conditions which are not in par with our country. So with this, I would like to conclude my set of arguments. And if the Lordship agrees, I would like to give the forum to my co-counsel to proceed forward with the next leg of arguments. Much obliged, Lordship.
You've done a good job. I appreciate you. Go ahead, speaker number 2.
Indeed, Lordship. Can your Lordship may confirm I'm audible?
You're not so clear.
Just a minute, Lordship.
Now you're fine.
Just a second. Okay, so I shall be starting. Your Lordships, I shall be presenting before you the arguments pertaining to the issue 2, which says that whether or not section 115 BBH of the Income Tax Act is a violative of the Constitution. Your Lordship, while presenting my arguments are based on basic 4 pillars. First, that the government is having a sovereign power to tax. Second, the rational nexus behind the taxability. Third, that the taxation is not a violation of any fundamental rights. And fourth, why the petition is devoid of merits. Your Lordship, the government ruling the sovereign country of Republic of Parlamento is sovereign, democratic, and republic. It is bestowed with the powers and rights under the Constitution of Republic of Parlamento. Your Lordship, Article 265 of the Constitution provides the government an authority of law, and such authority of law can find its root in the Article 246, wherein under Schedule 7, List 1, Entry 82, the taxability of the income is mentioned. Thus, the government is well within its total rights to tax the incomes which is generated from the virtual digital assets. Your Lordships, the tax is a sovereign right, and it is tried in law that mere rate of taxation and the method of taxation cannot be challenged before the court of law.
Can I
Your Lordship,
ask
it is
a
not about.
small doubt? Yes,
Your Lordship,
government has got, as per the articles of the constitution, whatever you mentioned, government is within the law. But isn't there a procedure to be adopted?
Your Lordship, as far as the procedure is concerned, so the matters of taxability or the non-taxability is a policy matter. And nowhere in law it is mentioned that the taxation has to do with the legality or the illegality of a particular income. Your Lordship,
Policy, when you say the policy of the government, policy cannot be challenged?
indeed, Your Lordship, policy cannot be challenged until and unless it is a violation of a fundamental right, which
Yes,
the petition,
yes, that
which
is,
the petition,
petitioners are on that only.
Your Lordship, if you refer to the memorial presented by the petitioners, they are not contending that it is a violation of fundamental rights. Petitioner fails to mention a single fundamental right that is being violated. If Lordship is satisfied with the argument, I shall be moving forward.
Go ahead.
Indeed, Your Lordship. Your Lordship, the democratic government is making the law keeping in mind the good for the interest of the public. Your Lordship, considering the present nature and the status of the virtual digital assets, the government thinks that a cautionary approach can be taken. Thus, a 30% of the taxation is in the benefit of the people. Your Lordship, as presented by my co-counsel, the virtual digital assets are posing multiple questions. Like they are not centralized, they are not regularized, the transaction can be anonymous and untraceable. Thus, Your Lordship, it can become a potential use for the negative use of it. If Your Lordship may refer to para 3 on page number 11 of the memo. Is Your Lordship with me?
You go ahead.
Your Lordship, there the government has presented that it is taking a cautionary framework based on the reports, and thus it can be followed till the time.
Reports of.
Your Lordship, it is a report of PRS Legislative Research. It was dealt by the committee report summary in the virtual currencies in India, and it was it is mentioned as the footnote 20 in the memorial.
Yeah, please read it for me, no?
Yes, Your Lordships. So, Your Lordship, the Union government is in the process of making it stand clear on the virtual digital assets, including the virtual currencies, and the government has already done a serious deliberation upon the issue. The preliminary finding of the report suggests that the government should take the cautionary step for the time being, till the image of the VDAs is in the legal ambit becomes clear. Thus, Your Lordship, it is possible that the reforms can.
Cautionary step.
Indeed, Lordship. Indeed, Lordship.
Yeah. But you already acted on it.
Your Lordship, the government has not declared it legal or illegal. The caution is in the sense.
Not legal, illegal. Yes, that itself is a question, whether it is legal or illegal. That
Indeed.
is one issue, one aspect of it. But
Indeed,
without looking into legal or illegal, you already implemented 30% tax.
Your Lordship,
that's why the petitioners are here. Agreed by
Your
that.
Lordship, as far as the position, Your Lordship, as far as the position of law is concerned, my co-counsel has already mentioned 3 case laws pertaining to the same fact. It is saying that the legality or the illegality of a particular source of income does not matter to its taxability.
But
as far as the taxation of a particular income is concerned,
again, the tax is income tax. Here you are charging an extra tax.
Your Lordship, it is only the first tax. It is not charged on a particular amount. It is charged. It is being charged on only on the transfer of the crypto.
You are charging 30%, which is challenged by the petitioners.
Indeed,
they are willing to pay the normal tax.
Indeed, Your Lordship.
So how can you say that you are right in charging 30%?
Your Lordship, as far as the section 115 BBH is concerned, the 30% tax is only 30% tax is levied as far as the normal tax is concerned. So the income generated by the cryptocurrencies shall not be a part of the total income slab. The section 115 BBH pertains to a special tax, and hence the consideration of the income which is being earned by the cryptocurrencies is outside the purview of the income tax slab. Thus,
this section 115B, this section is under IT Act, isn't it?
Indeed, Your Lordship.
So how can you say it is not under the purview of IT Act?
Sir, it is under, Your Lordship, it is under the purview of the IT Act, but as far as its nature is concerned, the sections, as far as the 115 series is concerned, as far as that is concerned, it will not be a part of the slab. It is being imposed as a special tax under the income tax slab only. If Your Lordship may refer to the section 115BB, which pertains to the income earned by gambling also. Your Lordship, in that case also, 30% tax is applied to it.
Yeah.
If Your Lordship is satisfied, I shall be moving forward with the further arguments.
Go ahead.
Much obliged, Your Lordship. Your Lordship, in that manner, a 30% tax which is being levied on the income generated by the virtual digital assets is solving the.
Your voice is not heard. His network, I think, is having a problem.
The legality issue can be solved, which the government is in the process of doing.
1 minute. You were off the line for some time. You please repeat what you said.
Indeed, Your Lordship. Your Lordship, the counsel for the respondent is saying that the 30% of the tax is solving the two purposes. First, it is generating the revenue for the government, and second, it is also working as a first screening for the legitimate use of the VDAs. Thus, Your Lordship, as far as the taxability is concerned, the step of the government is very constitutional. Your Lordship, now moving towards
1 minute. What is the applicability of this law to the fact?
Your Lordship, pardon?
The applicability of this law.
Indeed, Lordship.
Whom it is applicable?
Okay. Your Lordship, the particular legislation under section 115 BBH is applicable to the people who are earning in the cryptocurrencies, who are transferring the cryptocurrencies. The tax is not levied on the on the VDA per se, but the tax is levied on the transfer of the income which is generated from the transfer of it.
Okay.
Thus, Your Lordship, the second leg of my arguments is dealing with the rational nexus. Your Lordship, as far as the very nature of the virtual digital assets are concerned, so it is having an intelligible differentia, and thus it is separated from the other incomes. Your Lordship, if we talk about, for instance, if we take the income which is generated by the share market, so Your Lordship, there exists an intelligible differentia between the two sources. As far as if we talk about the share market, Your Lordship, it is legal.
This is also identical to that only, no?
Your Lordship, but there exists an intelligible differentia which I am putting forward before you.
What is the difference between the two?
Indeed, Your Lordship. Your Lordship, the share market is certain. It is centralized by a regulated body. It is regulated by SEBI. It is accepted much and it is traceable. But as far as the virtual digital assets are concerned, so all of these attributes cannot be found to it, and thus it cannot call for an equal treatment. And thus,
see, my question is, why do you need why do you need to know the source? You need to have the you know that I am having this much money which has come through cryptocurrency.
indeed.
So for that you can ask for the tax, no? But why do you need this source for that?
Your Lordship, for the legitimate use of a particular income, the source must be known. Considering that if that particular source of income is used for taxing the...
Your colleague has just submitted, when it is illegitimate or legitimate, it can be taxed.
Your Lordship, the legitimacy and the illegitimacy is not in the purview of the taxation. But as far as the other punitive laws are concerned, then the source of income must be known. As for considering the fact that the income is being raised for the purpose of terrorist activities, extortion, and other purposes. So in that manner, it must be used.
This is where I am not able to understand. You are attributing to terrorism, money laundering, and all. A common man also using this money, he is also will be labeled a terrorist.
Definitely not, Your Lordship. As far as the taxability purpose is concerned, that is where I say that it would be considered as the first screening when
Let me tell
will
you
be
one
taxed.
thing. During
Indeed.
the COVID only brought in these cryptocurrencies and everything in a rampant use, right?
Indeed.
Okay. Even so in such a situation, when the common man is also using it, we should be encouraging it, no, than discouraging it.
Indeed, Your Lordship. Your Lordship, on that fact, I would like to submit that as far as the traceability is concerned, that is where the eyebrows can be raised for the negative use of it. But the government and the taxation of 30%, that's where I submit that will be working as the first screening. Because if a particular income will be taxed, its source will be known. And thus, as far as its negative use is concerned, that will be kept at check. Thus, the people who are doing a legitimate use of it shall be using it in a very regular manner. But as far as the negative use of it, that will be taken into consideration for the cautionary purpose. Thus, the source of income will be traceable. And if it is used for extortion, bribery, terrorism, that will be come to known to the authorities, and thus it will be helping in that manner also. As Your Lordship is satisfied, I shall be moving forward.
Go ahead.
Much obliged, Your Lordship. Your Lordship, as I've earlier stated that the petitioner is not mentioning any specific fundamental rights that are being violated, but for the purpose of brevity and justice, I shall be presenting before the Lordship as how the particular taxation is not a violative of the fundamental right. Your Lordship, under Article 19(1)(g), people are given the fundamental right to trade in commerce, but Article 19(2) also deals with the reasonable restrictions. Thus, if the restrictions are in the national interest, then such restrictions can be put forth. Your Lordship, in the case of Internet Mobile Association versus the RBI, the petitioners also raised the contention that the restrictions put by the RBI on the cryptocurrencies is restrictive to their fundamental right. If Your Lordship may refer to para number 9, there I have quoted the same judgment where it is said that the person who are using cryptocurrencies as a hobby cannot take the relief under Article 19(1)(g). Moreover, if the person are using the cryptocurrencies,
19(1)(g). Let us not talk about 19(1)(g). We are restricting ourselves only to this 115B of the IT Act.
Indeed, Your Lordship, but as far as the constitutionality check of the particular legislation is concerned, so that have to be done on the annuals of the Constitution itself. And thus, for the legality check, I shall be comparing it with Article 14, which I earlier did by giving you the rational access and the intelligible differentia. And for the purpose of the right to trade and commerce, I shall be using the Article 19(1)(g), because it is giving the right, and it is done keeping in mind the brevity and the justice. So, if I may continue.
Go ahead.
Much obliged, Your Lordship. Your Lordship, as far as the second category, that is the business and the trade in the cryptocurrencies is concerned, they shall also not be able to use 19(1)(g), considering that the particular legislation which is only taxing, it is not hampering upon the business, considering that it is not totally shutting their business down. Thus, 19(1)(g) is not available to them. Your Lordship, as far as my last leg of the arguments is concerned, I shall be presenting before you that why the petition is devoid of merits. As I've stated earlier, that the petition or the particular legislation is not being challenged on the anvils of the violation of the fundamental right. Thus, it cannot be challenged before the Honorable Court. Your Lordship, in the para 9 at page number 11 of the petitioner's memo, they are contending that the virtual digital assets is not a part of the 7th schedule. Your Lordship, as I mentioned earlier, the government is not taxing the virtual digital assets, but the government is taxing the income which is being generated from the virtual digital assets, which the government is having a right under Article 246, Schedule 1, List 1, Entry 82. Your Lordship, thus, there is no question to the legitimacy of the authority of the government.
Mr. Speaker, your time is up.
If Your Lordship may grant me 2 minutes, I shall be completing my submissions and giving you the praise.
Go ahead.
Much obliged, Your Lordship. Your Lordship, the two case laws that are cited to check the authority of the government of Parlamento basically belong to the foreign governments of Canada and Canada and UK. Thus, they shall be having no applicability as far as the legitimacy of the government of the Parlamento is concerned.
They have
Your
not.
Lordship,
They have not quoted the judgments of other countries to be invoked here, but they said for persuasiveness.
indeed, Your Lordship. Your Lordship, in para 10, the petitioners have accepted the fact that the legality or the illegality of the income does not matter in the taxability. Then, Your Lordship, as far as the para 12 is concerned, they have mentioned a case which shall not be applying.
Legality or illegality is not considered, but you can tax. Sir.
Indeed, Your Lordship, my co-counsel has
If
given
it is an
3 case
illegal
laws.
income, it can be confiscated, isn't it?
Your Lordship, as far as Your Lordship, that is the matter of the punitive charges and the legislation which are punitive in nature. But as far as the income tax is concerned, if Your Lordship may refer to section 115BB, Your Lordship, it is taxing the gambling, and gambling is already illegal in India under Public Gambling Act of 1867. But it is an illegal income, it is still taxed. On the same lines, even if in future, thus it proves that the legality or the illegality doesn't matter. The Income Tax Act is only dealing with the income, not the nature of the income. The nature of the income is being dealt by the other punitive laws. Your Lordship, thus, if Your Lordship may refer to para 6 on page number 12 of the respondents, Your Lordship may find that Article 32 cannot be agitated for a means to indicate the policy preferences. Your Lordship, the petition of the petition in hand is basically a policy.
Policy preferences cannot be challenged. You say it cannot be challenged. How do you say that? On what grounds?
Your Lordship, there is a case that I have cited as footnote 23. It is named as Hindi Samiti versus Union of India. Your Lordship, it was delivered by DB, and the policy matter was that in the exam of PMT, Hindi was not given as a language, and it was the contention of the petitioners. But Your Lordships in that case held that it is a policy matter of the government, and as far as the contention of taking Hindi is considered, it was an indicative to the policy preference. Thus, it was not considered at that time, Your Lordship. And I'm invoking the same case law here for the matters. So, Your Lordship, on the basis of constitutionality, as far as the grounds are considered, the government is having a legitimate source. The government has delivered an intelligible differentia and rational nexus. The government has also proven that there is no violation of a fundamental right. And also the government has proved that the petition in hand is devoid of merits. Thus, on the same grounds, I would humbly request the Honorable Justice to quash the petition prima facie. If Your Lordship is satisfied, I shall be moving forward with the prayers.
Is it quash the petition or dismiss the petition?
Your Lordship, it shall be dismissed. Pardon, Your Lordship.
And now you can close your any rebuttal.
Your Lordship, I shall be delivering the prayers, I believe. If Your Lordship may
already
permit.
prayed, no?
That is our major prayer, and indeed, Your Lordship, indeed.
Anything else is there? That's your main
Your
prayer,
Lordship,
right?
Indeed, Your Lordship, it is our main prayer.
Yeah. So go ahead. Any rebuttal?
Indeed, Your Lordship, there are 3 rebuttals that are that the counsel for the petitioners would like to put forth to the learned counsel for the respondents. At the outset, there were many, this is not a rebuttal, at the outset, there were many averments and false averments made by the respondents against the petitioner regarding fundamental rights. It's a kind request to ask them to restrict their arguments only to what is given in the written submissions and oral arguments, because there are certain...
So what is it that they went beyond their brief?
They allege that we went...
They have made a point, 1 minute. They have made a point that you have not come under any specific article challenging.
Indeed, Your Lordship. Indeed, Your Lordship.
Is it right or wrong?
We have not gone into the merits of any fundamental rights, and the same was also displayed in the...
It has to be there, no? It has to be
There
there.
has been a constitutionality was dealt with in different grounds, Your Lordship. So the questions for the rebuttal are as follows. There are 3 questions in total, and the first one would like to the counsel for the petition would like to direct the learned counsel for the respondent to paragraph 1 and 3 of the page 9 of the respondent's written submission, where they themselves have acknowledged the absence of a regulatory framework, and there has been a contention to various contentions regarding the registration of the transactions in VDS world. So the question is, how would the learned counsel for the respondent like to justify a lack of machinery and procedural provision provided by the tax regime, which should best befit a legislative framework? The second question is regarding how would the learned counsel for the respondent argue regarding the lack of legislative competency? Because under Article 265 of the Constitution, there needs to be one, and only under the authority of law can it be taxed, where the legal position and the present hand is unknown. And the third question is, how is the government justified when it comes to taxing as it violates the doctrine of intelligible differentia based on the different slabs of income heads that a VDA might, virtual digital asset might fall under?
Any rebuttal for you on the respondent side?
Indeed, Your Lordship.
Anything is there?
Indeed, Your Lordship. I'm having the answer to all their questions. So, Your Lordship, as far as the first rebuttal is concerned, which relates to the para 1 and 3 at page 9. Your Lordship, there the petition is questioning the regulatory framework, but as far as the co-counsel and me myself have submitted before you, that the government is still in the process of making the regulatory framework, but it does not mean that we cannot tax it. The legality and the illegality is not the question here. The question that was framed by the Supreme Court of Parliament was the taxability of the VDAs, not the legality of it. Thus, Your Lordship, that rebuttal stays of without any merits. Your Lordship, second question is regarding the legal position. As I have stated in my submissions, Article 265 is giving the authority of law, and such authority of law can be found under Article 264, subclause 1b, wherein it is stated that the government can make laws which are mentioned in the 7th schedule, list 1. The 7th schedule, list 1, entry 82 is mentioning that the government can make laws on incomes. Hereby, I submit that the government is not taxing the virtual digital assets, but the government is taxing the income which is generated from the transfer of the virtual digital assets, thus sufficing entry 82, list 1, schedule 7. Then, Your Lordship, as far as the third argument is concerned, is regarding the intelligible differentia. Your Lordship, the petitioner has defined the intelligible differentia, thus the differential treatment of the income, where one income is legitimate and the other is not. There cannot be equal treatment on equal grounds, and they cannot be treated at par. Thus, there is an unequal treatment of it, and such unequal treatment is protected by the Constitution itself, because it says the equality before law should be done in the manner of equity, which means the equals should be treated equally. Thus, if two items are not equals, they cannot be treated equally. Thus, Your Lordship, I submit my rebuttals.
Okay, I want to appreciate and congratulate. I want to appreciate and congratulate both the teams. Both of you have presented very well. And one thing that I could see is maybe due to the time frame, you people were rushing through. And another thing that you have to keep in mind is try to be interactive with the judges. Then when I have been trying to be interactive with you, but you were not giving me an opportunity to interact with you. You understood? So if you make a kind of interaction between the judge and the bar and the bench, then it will be much smoother. And both the prayers, the petitioner is supposed to pray that the section of law to be quashed. You have not mentioned that. And the respondent counsel is praying for what? I corrected you. You should have told to dismiss.
Yes,
Instead,
dismiss.
you're asking to quash. Your petition cannot be, your thing cannot be quashed, isn't it? So these are all very minute things which you have to be careful, because the judges, when they are on the bench, they will be taking these things. You have not prayed for it. Hence, return it, amend it, or dismiss it. That will be the stand taken by the benches. So prayer is very important. I am just looking into the prayer of the petitioner. You say, go to your prayer. You are asking
Yes, Your Lordship.
to declare. It is, you should be asking to quash. And the respondent's prayer is to quash. The respondent should pray to dismiss it. You got it. And speaker number 2 in the respondent side is very fast. Why? You should not be tense. Your anxiety should not be seen in your face. All of you, I'm telling. Huh? You should be cool. The more the cool you are, your subject will be simply flowing from you. Huh? Don't be worried about the consequence of it. There will be other arenas to address it. What you are doing, you do it in a very composed manner. Present it in such a way that the person hearing it will understand. When you go it'll be difficult for the judge to understand, right? Huh? So keeping all these things in mind, I wish you all the best. The winning team, keep these things in mind, because you are going to represent before you are going to represent before the High Court judges. Huh? And because I told that they are going to be High Court judges, panic button should not be pressed. I am telling you, I am preparing you that you should be very cool, and your time should be very within your control, and try to interact with the judges. Okay? Wish you all the best. God bless you.